FEMA. This time I will call 125761, State of Kansas versus Collins.
May it please the court, Casinroyial Collins appears to counsel Caszarone, Kansas appellate defender. The district court did not advise Casinroyial Collins of his appeal rights when revoking his probation and sending him to prison for 13 years. Nobody came to the jail to talk to Casinroyial about his appeal rights until over half of the 14 days that he had to file a notice of appeal had already run. And even then, he did not get complete notice of his appeal rights. Despite all of this, Casinroyial Collins managed to secure a notice of appeal within 8 days of that jail meeting.
We don't know that from the record, though, that he didn't get complete notice. I mean, we don't really know whether his attorney advised him that he had a right to counsel, even if he were indigent. It's just, there's an absence of reference to that, isn't there?
I have two responses to that, Your Honor. If the court finds that the evidence is lacking, it was the state's burden to put on evidence of showing that Casinroyial got notice of his appeal rights from some other source. So if it is lacking, that's the state's problem, not Casinroyal's. Second, I want to focus on precisely what defense counsel said. He said that Casinroyial, and I'm quoting, still was afforded the right to appeal, and that there are appellate attorneys that are more versed in appellate law, and that if he wanted to file the appeal, I would file appeal. It would then be out of my hands, and he can talk to an appellate attorney about it.
But that's not advising him that he has a right to an attorney at no cost if he's indigent.
That's exactly the problem,
Right.
Your Honor.
Okay, so can we infer it?
No.
I mean, we have some case law where we can infer that the district court made findings that aren't directly referenced.
We cannot do that here, Your Honor, because this would be inadequate if this was the district court's rights advisory. That's not enough. The district court has to advise somebody who has the right to appeal that specifically they have the right to appointed counsel. Court didn't do that. This would not have been enough if the court had said this. And since it would not have been enough if the court says it, it can't be enough to cure the court's failure.
Now, the state says, well, he's had other cases. He knows that.
Not as an adult, Your Honor. This was his first experience. Casinroyial was 18 years old at the time of his revocation hearing. This was a juvenile case that got waived up. This was his first experience with the adult criminal legal system. Any experience that he had with the juvenile legal system really isn't the same. This was the first time that he'd had his probation revoked in an adult case, and he would have had absolutely no reason to know what his appeal rights
were. Help me understand what if we presume your argument to be correct, help me understand the remedy here. What's the remedy that you're asking for? And let's flesh that out a little bit.
We're asking this court to reinstate the appeal.
Okay, but under that shifting burden of proof, it was the state's burden to show that there was actual knowledge. We don't have that here, but it seems like there's still one more step, a district court making a finding that the defendant would have actually pursued that appeal. And I'm wondering, I understand there's some evidence that suggests that, yes, in fact, he would have, but without the finding, does that box us in a little bit?
Not on these facts, Your Honor. The timing here is important. And Ortiz, at the end of the day, is about fairness. And the fair thing to do here, if he's where we know at the very least that he's not advised that he has 14 days to appeal his case until 9 days into the clock, the fair thing to do is start that clock when he's actually advised of his appeal rights. And he did secure a notice of appeal just 8 days after that. So this is a case where actions speak louder than words. When he was advised of his appeal rights, he made timely efforts to get the notice of appeal filed. When I reviewed this court's case law about what we're looking for when we're talking about whether an appeal would have been pursued, the appellant is not allowed to let the matter drop. Casinroyial absolutely did not let the matter drop here. When he was not advised of his appeal rights, he called his attorney to ask that attorney to come down and explain things to him. That didn't happen for over a week. And I understand sometimes there are reasons for that, but that is not Casinroyal's fault. It is not his fault that he lost more than half his time before he even knew that he had 2 weeks to appeal. And even after that, he was never told that he had the right to appellate counsel. And the difference between being told that there are appellate attorneys out there who are pretty good at this, you might want to talk to one, and being told that you will be appointed an attorney if you choose to appeal this case who's going to help you, is a very important difference.
So you're not really suggesting that, I mean, just to follow up on Justice Wall's question, which kind of infers, do we need to send this back for a specific finding? You're really asking us to kind of create a new rule here that we haven't done before that I'm aware of starting the clock partway through the time at the time of the point of advisement.
Well, Ortiz is a judicially created rule, Your Honor, so I don't see any reason why this court couldn't do that. And I think it would be the fair outcome here. Regardless, whether this court goes that route or not, we do see Casinroyial taking prompt action once he's informed of his appeal rights. And that's inconsistent with the finding that he wouldn't have appealed had he been timely advised.
So we can reach a conclusion as a matter of law based on the circumstances that he would have pursued the appeal. Is that the argument now? I mean, is that what you're saying? I'm trying to just connect the dots.
Sure.
How we get
No,
there.
and the first two prongs of the patent analysis, and patent, of course, is the case that lays out the burden shifting test, are certainly legal conclusions. Did the court advise? Well, we've got a transcript. We reached the legal conclusion that either the court did or didn't. Did the state meet the burden of showing he got the advice from somewhere else? Well, we've got the record. He either did or he didn't. The third patent factor, I think, needs to be treated the same way. If the first two are legal conclusions, then the third one should be too. And here the facts support the legal conclusion that, you know, when he's advised of at least part of his rights and he appeals within 8 days, yes, as a matter of law, he satisfies that factor.
Doesn't Patton go against that though? Because Patton, let me set it up a little bit. Patton addressed many, many different factual variations of what can happen, what the defendant's knowledge might be. And then it boiled it down to this simple three-phase nut, if you will. As to the first exception, Patton requires that a district court provide a defendant with 3 pieces of information. 1, a right to appeal the severity level of the sentence. 2, any appeal must be taken within at that time 10 days. And 3, if the defendant is indigent, an attorney will be appointed for the purpose of taking any desired appeal. Okay, that didn't happen. So then Patton said, if the defendant shows the district court failed, then the burden shifts to the state to prove that the defendant had actual knowledge of those 3 things. And then if the state fails to carry its burden, which you assert that third thing that he's entitled to counsel if he's indigent never happened, was never proved, then you go to step 3. If the state fails to carry its burden, the burden then shifts back to the defendant to show that they would have appealed had they been correctly advised. So there are essentially 3 phases if the district court fails, then the state has to prove those three things somehow. If the state fails, then it shifts to the defendant to say, if I'd known that, I would have appealed, right? Isn't that what's required under Patton?
I think, Your Honor, that you've got the analysis right. I would push back on the idea that if Casinroyial doesn't stand up in court and say, if I would have been advised timely, I would have appealed within 14 days.
Well, isn't the problem here that phase 2 and phase 3 never happened? Couldn't that be resolved on remand?
That it could be resolved on remand. I just don't think that the court needs to remand it. I think based on the facts that we have here, this court can conclude that the only finding that would be supported by substantial competent evidence is that if timely advised, Casinroyial would have timely appealed.
How can we infer that?
I just don't see any other conclusion to draw from the fact that after he's advised of at least some of his rights, he gets his notice of appeal on file within 8 days.
Let me ask you a question about that. So the district court made a credibility finding about his attorney's testimony that okay, so the court emphasized his testimony regarding this meeting, and Collins didn't really remember the meeting, in particular at the jail. The court therefore credited his testimony, where Collins said, I don't want to file a notice of appeal. What do we do with that factual finding from below? Because, I mean, the case law says if somebody says, I don't want to file an appeal, and then you're saying, well, but we can infer from the fact that he later did it, that he did want to file an appeal, but that seems like a change of mind.
Sure.
You know, based on the factual findings from the district court. And I don't know what we do with the factual findings of the district court.
Well, Your Honor, and I think it runs together with the problem of Casinroyial was working with a very condensed timeline because he didn't get notice of his rights at the time of his probation revocation hearing. So presumably the reason the legislature allows 14 days and doesn't require you to say, yes, I'm appealing, or no, I'm not, right there from counsel table when the sentence is imposed, is that we want to allow people at least a little bit of time to think about this. And that can include changing your mind, right?
Right, but if the district court found that he said, I don't want to appeal.
Right. And the testimony further was that, on the 8th day, Casinroyial, after the jail meeting, Casinroyial got in touch with counsel and said, you know what, I do. And defense counsel therefore immediately filed the notice of appeal. So you're right. The facts the district court found show that Casinroyial reached one decision on the day of the jail meeting and then changed his mind and reached a different one 8 days later.
Right, and so.
I'm sorry, go ahead, Your Honor.
I was just going to say, so let's say we have a case with a little bit different facts and the defendant changes her mind 5 hours before the 14 days expires.
Sure.
So in that situation, are we to start the clock anew? Even though for the 13 and a half days, she said she didn't want to appeal?
No, I don't think so, Your Honor.
Mm-hmm.
I think what starts the clock is knowing that you've got 14 days, right? And the earliest that happened in this case is the day of the jail meeting. So yes, it took Casinroyial 8 days from the time he was told you've got 14 days to appeal to actually get that appeal on file. But the 9 days of delay that preceded that jail meeting were not Casinroyal's fault. They were
I'm sorry, I didn't mean to interrupt. I thought you were done.
No, I was just going to say they were due to the neglect of the district court in not putting Casinroyial on notice of his rights right away. And again, I'm not throwing stones here because I understand people are busy, but ideally the jail meeting would have happened much sooner than 9 days into the clock. It didn't, and none of that is Casinroyal's fault.
But if Mr. Casinroyial has not yet been advised that he's entitled to an attorney, if he's indigent, it's free to him. If he still hasn't been advised of that, and we don't accept the state's argument that, oh, he's had other cases, he knew that, then he still hasn't been advised of the 3 things he is supposed to know. So does that mean, under your argument, the 14 days hasn't even started yet?
I think that's essentially what this court now is describing, I think, is what happened in Scoville. And Scoville dealt with the court failing to advise the appellant of the, I think at that time it was 10 days, doesn't matter. But failing to advise the appellant of the time limit. And that was part of the McAdams situation. He didn't take an appeal for over a year.
So your
And
claim
this,
appeal is timely. It's not even late. Ortiz doesn't even apply, right?
in
Well, it's
Scoville,
not
Your Honor?
late. No, I'm sorry. In this situation, he hasn't been advised yet.
Right, right.
His
And
appeal isn't even late.
I think that's right under the Scoville logic, Your Honor. Basically what this court said in Scoville was, well, he was never fully advised of his rights. Therefore, he gets to take an out-of-time notice of appeal. And arguably we're skipping a patent step there. But I think the way to read that is, when you're never advised of your rights, your clock never stops. Your clock never starts. And I see that I'm over my time here, so I appreciate this court's attention. I will conclude by asking this court to reverse the Court of Appeals in the District Court and to reinstate this appeal.
May it please the court, Assistant District Attorney Chelsea Anderson on behalf of the state of Kansas. As we know, this matter stems from the defendant's attempt to appeal his probation revocation, which was filed 3 days out of time. As the questions have addressed the first exception to the Ortiz matter, I will start there and note that the defendant claims that this argument that he was not fully informed was always before the court, and that the Court of Appeals therefore was wrong in finding that it was an unpreserved matter, despite appellant arguing specifically for the exceptions to consider unpreserved arguments in his opening brief, clearly anticipating that the Court of Appeals would find that it was a new argument. His petition for review then asserts, as I stated, that he's always made this claim, and he cites to the closing argument from the Ortiz hearing in support of that. However, this appears to be factually incorrect and ignores the manner in which the argument was made at the hearing. The state can only address the matters that are challenged, the issues that are brought before the court, and the defendant simply failed to explore that information. Despite the defendant's complaint that he was faulted for the incomplete record, the Court of Appeals was correct in placing that burden on the defendant, as it is a well-established rule that the appellant has the burden to designate a record sufficient to establish the claimed error. And without an adequate record, the appellant's claim of alleged error fails.
Well,
This-
wasn't it the state's burden to prove that those three elements did actually exist with the district court's failure to do so?
Well, the state would have been required to, if it had been properly on notice that that was being argued. I would know.
Didn't the Court of Appeals just get it wrong and put the burden of proof on the defendant instead of the state?
No, I would say that they did not get it wrong. That was another argument, that the burden was improperly shifted to the defendant. But as you noted, and I think Justice, I believe Wall noted, that there is another step, that Patton said that if the transcript shows that the defendant was not adequately informed by the district court and the state does not demonstrate actual knowledge, then the defendant must prove that a timely appeal would have been filed. And as the court has already noted, credibility findings were made, and this court does not reassess those findings. And the district court, in making those findings, determined that that factually the defendant would not have timely appealed. Now, again, I note that I would argue that the state was not actually on notice that all three advisories that are required post-sentencing were at issue here. This was, again, from a probation revocation, and the response to the show cause order indicated only the third exception of Ortiz. Then the counsel who is appointed for the Ortiz matter filed a motion to reinstate appeal, which really wasn't necessary, but was filed. And at that point, it was expanded to include the first exception, but he only argued that the court had failed to advise the defendant of his right to appeal.
Do you disagree, just for my clarity, you don't disagree that what I'll call the first step, that the transcripts show that there was not an adequate advisory from the court?
I do not disagree that the court did not advise the defendant at the conclusion of the revocation hearing.
Okay, so your preservation argument goes to what the state would have had to show about actual knowledge?
I'm sorry.
I
just want to make sure I understand exactly what you're asking.
Yes, we're trying to understand each other. I appreciate that. It sounded to me like your preservation argument was, look, we acknowledge we have the burden to show actual knowledge, but the defendant didn't put all three prongs of actual knowledge into issue.
Correct.
And does a defendant have to do that once they've made the transcript showing?
Well, the state would argue yes, because again, the state.
Why would they, just conceptually, why would that be the case when our case law is very clear about what the state has to show? I mean, doesn't our case law put it in issue essentially?
I suppose the court could interpret it that way. The state believes that it was a conscious decision on the part of defense counsel to hone in specifically on the court's failure as well as just the 14-day timeline. And that was what the state was responding to. As you can see from the closing argument made, as the Court of Appeals noted, the defendant did not challenge whether the state met its burden, nor argue that the state had failed to establish that the defendant had actual knowledge at the district court level Ortiz hearing. Therefore, the Court of Appeals, like I said, was correct in finding that this was a new argument unpreserved for appeal, because it would have required the Court of Appeals to engage in fact-finding or assume facts not in the record, which, as I mentioned earlier, it is the defendant's burden to establish that record.
But the district court ruling landed it didn't go past the first step, did it? I mean, didn't the district court ruling find that there was, I'm sorry, second, maybe it's step. Was the ruling that there was an adequate advisement or that there was actual knowledge, or was it an alternative ruling by the district court? Can you help me remember the record there?
As I recall, the district court did indicate that it felt the state had shown that the discussion that probation counsel had with defendant did cure the that, but ultimately, I think the main finding was that the district court believed the defendant would not have timely appealed had he been so informed or had there not been any deficiency in his representation.
Does that finding take into account an adequate advisement that would include the right to appointment of counsel? Do you understand what what I'm asking there?
I just want to make sure, are you saying does the finding that the court's lack of advisory was cured? Or are you saying the final?
The final finding that he did not want to pursue an appeal, I guess, does it matter does that finding presume that a actual knowledge of the full extent of the right to counsel, that the defendant was aware of that full right, and even if he had actual knowledge of the full right, would have not pursued an appeal? I guess if the district court makes a finding that he didn't want to pursue an appeal, but there's not actual knowledge of the full extent of the right, how do we square that factual finding with this sort of legal deficiency, if that makes sense?
Well, as I stated, this court has said in Patton that, based on the Patton analysis, I don't think it does matter whether the court is able to find that the state met its burden, because ultimately the burden shifts back to the defendant to prove that he would have timely appealed had he been properly informed. And I think one of the things that I noted while opposing counsel was arguing his side, there was a lot of talk about this time period that went by before he got over to the jail, which ignores the fact that the probation revocation attorney also testified that immediately after the hearing was over, he advised him of his right to appeal and said, let me know if you want to discuss it further. Now, again, it wasn't explored what that entailed. It wasn't explored whether he just said, hey, you have a right to appeal, call me if you want to, or if he said all three things. I mean, you could easily say all three things in less than 90 seconds, which was the testimony. So again, it wasn't explored. And I believe based on what this court has previously said, it is absolutely the defendant's burden, as even in Patton, with regard to that first exception, this court said that the evidentiary burden rests on the defendant. So, and specifically said, even if the state can't demonstrate that actual knowledge, the defendant must establish he would have appealed.
Isn't the best evidence for what someone would have done if something was different, what the defendant actually did? I mean, that's opposing counsel's argument is, look, we don't have to speculate. We know what he actually did. What he actually did was file the appeal within 8 days.
Well, what we know is that he was told he had a right to appeal. He immediately calls the probation revocation counsel and wants to, address it further. So this argument that, well, only 8 days passed is inaccurate. He knew immediately after the hearing that he had some right to appeal. Now, it's arguable whether he was told of the timeline. I don't know, because it wasn't developed down below. But the bottom line is he was told he had the right to appeal. He said, yeah, let's talk. And the attorney goes to the jail with the full expectation that he's going to be filing an appeal for this guy. And then the guy says, no, never mind. I don't want to, after being fully advised. So,
But
yes, but
concerning appellate counsel, though, doesn't the record reflect that Mr. Royal's attorney told him, if you want to file an appeal, I'll file it and then we'll talk to an appellate lawyer who knows a lot more about those things than I do. I'm not going to assume that if somebody tells me I can go to the doctor to talk about something that they'll know more about, I'm not going to assume the doctor's going to see me for free and that everything is going to be taken care of at no cost to me. Don't you think that his conclusion might be a little different if he knew that he could appeal for free?
I don't know. Again, it wasn't established. It wasn't developed. There were no follow-up questions whatsoever.
We have an odd situation here where it actually, what Justice Wilson says rings very true. It actually benefits the defendant a great deal if if it were true that at the jailhouse meeting, the defendant was actually fully informed of his rights, because that gives a clear reason to change one's mind. Oh, I can do it for free, right? So why shouldn't the defendant get the benefit of that?
Again, there's no basis for this court in the record to determine that he didn't know that. It
But
wasn't.
that doesn't, that suggests the state should lose, don't you think? Because if a defendant takes 8 days between the time the defendant finds out that he can appeal with state appointed counsel, finds that out, and 8 days later it gets filed, I mean, that's pretty strong evidence that he, quote, would have filed the appeal had he been fully informed.
But that's unfortunately not what you have before you. You don't have those facts. You have a probation revocation counsel saying, I told him immediately after, you've got a right to appeal. We don't know exactly what that conversation was because it wasn't developed. And then we've got this conversation at the jail with his appointed attorney, who had an appointed attorney throughout the entire pendency of the.
It does put the state in the odd position of arguing that the defendant should lose because there's no evidence he was ever fully informed of his rights.
Well, this court
Right.
would be well within its right to remand for more fact finding, but unless this court is going to go against precedent, this court doesn't make engage in fact finding. So I understand that we're in a little bit of a predicament, but I do think that ultimately Patton indicates that the burden is on the defendant. And I see I'm out of time, so unless there are further questions, I will ask this court to affirm the courts below. Thank you.
May I ask one more question?
Yes.
Do you agree that the state did not prove during the Ortiz hearing the defendant had been advised that he could appeal for free if he was indigent?
I believe that wasn't developed, so it wasn't in the record. Thank you.
Thank you.
Unless this court has questions, I think I'll briefly close my argument the same way defense counsel closed his at the Ortiz hearing, which is Casinroyial did everything that we would want him to do in this situation. And he shouldn't be penalized for that. He shouldn't be in a better position by going back to the jail and twiddling his thumbs for 17 days and then filing a notice of appeal after not being advised in court. He took action. He didn't let the matter rest, and he shouldn't be in a worse position for doing that.
So can I explore your argument has some resonance just in terms of fairness and based on the timeline, but it does raise perhaps a wrinkle in Patton that this court has never really addressed, which is this whole idea that the state, even if the advisory is not given by the court, the state can still prevail if they demonstrate actual knowledge. I don't think Patton or any of our cases say what is supposed to happen if the state succeeds in demonstrating actual knowledge. In other words, does the 14-day clock start over? That's
Right.
kind of your argument, as I take it.
Yes.
Can you address that? Like, for example, what if we had a hypothetical where the court does not advise and the evidence is overwhelming and even uncontroverted that the hypothetical defendant received actual knowledge 13 and a half days? You know, Justice Standridge is only 5 hours before the deadline expires.
Right.
What is supposed to happen? Do we have any case law, or what's your argument about? I think I know your argument, but.
No, I don't think there is any case law on it. And I assume that's one of the reasons why we're here today, Your Honor, to be quite honest. But, you know, as I think I said it earlier, at the end of the day, Ortiz is a court-made exception in the interest of fundamental fairness. So I think it is absolutely within this court's power to clarify what we should do and to set a fair rule. And I think the fairest, easiest to apply rule is to start the clock when notice
And
is
your
complete.
argument, if I could summarize it and see if you agree with it, is that we should essentially clarify Patton's third step, or the third step of proving that you would have filed the appeal, by saying you would have filed the appeal within 14 days of receiving the proper advisory, as opposed to the defendant who's 13 and a half days in having to file the appeal within 6 hours or 12 hours.
Yes, I think that would be fair and logical. It doesn't make any sense that an appellant who gets notice 13 and a half days in is functionally without remedy, and somebody who gets notice 14 and a half days in is in great shape.
Right.
That's neither fair nor logical.
Any other questions? Thank you, counsel.
Thank you, Your Honor.
Thank you to both of you for your arguments this morning. The court will take this matter under